My name's Jim Prout. I'm an attorney in Albany. I used to be in Troy for 30 years. I'm in Albany now for 2 years. As you probably all know, I'm one of the Co-Chancellors of the Diocese. That's relatively new as well for me. And I don't have all the answers about diocesan questions. Especially review forms. So anyway, we're here to talk about estate planning. And this is really just a really broad brush discussion about estates, estate planning. And I know a lot of you in the room, not a lot, some of you in the room. And I don't know where you all are on your estate planning journey. But if this is your start, then this is a good place to start, I guess. So anyway, estate planning, what is it? What is it? It's the planning for the use, preservation, and distribution of your assets, okay? A lot of people, when they come to me, they go, well, I don't really have any assets, you know? And people don't really think about what their assets are, I mean, unless you're focusing on estate planning. And all your assets are all the property that you own individually. Includes bank accounts, automobiles, your house, life insurance, investments, savings bonds, anything that you own, jewelry. When you add all that up, you know, it's very likely you have a larger estate than you imagined. It also includes property that you own jointly with another individual. So spouse or children, if you have joint bank accounts, that's part of your estate. Your house, again, investments, anything that you have jointly with another individual is part of your estate. And also property that you transferred to another individual but retain control over. Sounds kind of odd, but a lot of people transfer their home to their children and retain a life estate, okay? What that means is they own it during their lifetime. Upon their death, it automatically becomes their children. So, but that is part of your taxable estate because you retained use of it. So why do we even do preservation of our assets? One of them is planning for incapacity. You know, we're all getting older every day, and a lot of us, unfortunately, might end up with not the capacity to manage our own assets. So that's one of the things that we do with estate planning. Medicaid planning, that is when you shuffle your assets around, I like to say it that way, so that if you ever have to go into a nursing home, maybe some of your assets can be protected for the next generation. That is a whole seminar of its own. That's all I'm going to say about Medicaid planning. And then planning to reduce or avoid estate taxes. We'll talk a little bit about that later. But distribution of your assets. If you have no will, if you have no will, no trust, and you have assets that are in your name alone, not joint with another individual, the New York State statute tells us how those assets are distributed. And it really is based on what your family structure is. So if you have a spouse and children, $50,000 plus 1/2 of the balance of your estate goes to your spouse, and the balance goes to your children. I've had many clients come in that weren't my clients before this event happened, and they say, you know, there's no will, I'm the surviving spouse, I get everything, right? No, you don't get everything. You get $50,000 plus 1/2 of the balance, and your kids get the rest. And that's always a real shock to people, because people just assume that if you're married and I die, and my wife's going to get everything. Well, that doesn't work that way. If you have a spouse and no children, then it all goes to your surviving spouse. If you have children and no spouse, it all goes to your children equally. And if you have no spouse, no children, but one or both of your parents are around, it goes to your parents. So it's really based on what your family structure is at the time of your death. That's what the New York statute says. So that's one way that your assets will be distributed if you do nothing. Another way you can distribute your assets is gifting during your lifetime. You make gifts to your kids, you make gifts to whoever. The church, the diocese, you make gifts like that. I was paid to say that, no. So anyway, wills. If you have a will, that's where you determine where your assets are going as opposed to the state of New York. And so, you can do whatever you want with your assets in your will. Will substitutes, those are things like in trust fors. You go to the bank, they're like, oh, put it in trust for on your account. I'm going to tell you why not to do that, but let's go on a little further here. Joint accounts, putting everything in joint name, it all goes to the surviving spouse. Great. First spouse dies, now it's all in the surviving spouse's name. They don't have any will. Guess what? They have an intestacy. So there's a lot of reasons why you don't just use a will substitute in order to pass assets, because maybe your surviving spouse won't have the capacity to make a will when they inherit it. Maybe they're already in a nursing home, incompetent, and you die, surviving spouse gets everything, then the state of New York determines how it goes. So what can wills do? Wills can transfer your assets according to your own plans. They can provide for charitable institutions, such as the Diocese of Albany or your own church. Appointment of a guardian for minor children. So if you have minor children up to age 18, you can appoint the guardian of your kids in your will. If you don't do that, depending on who your kids are, there might be a fight over who becomes the guardian of your kids, okay? So really, if you have minor children, best to do a will, appoint a guardian, appoint a successor in case that person's not available. You appoint the executor or administrator of your estate. So again, if you don't have a will and you don't have an executor appointed in your will, then it goes by statute who gets to become the administrator of your estate. And you may have 4 kids, and your first one might be a complete loser, the second one might be really good with money, the third one, okay. So you pick the second one to be your executor, but if you don't have a will, it's probably going to go in the order of age. So another reason to have a will.
So I've got a question related to that.
Okay.
You have a will, you have an executor, you have one child. Everything goes to that child. But
Yep.
in the meantime, your executor dies, which is older than you. And now your child becomes both the administrator of the will and the beneficiary.
Yeah.
That's
okay.
That's okay?
Yeah, in fact, a lot of people that have only one child will name their child as the executor of their will. Because why muddy the waters and bring another party in,
So then it's just a passage of paperwork.
Yeah, if so, we generally put a primary executor and a successor executor in a will, just so that's a backup plan. But if they're both gone, then it'll go towards the intestacy. And so if you have the one child, that's the person that would be the administrator if there were no will. So that person jumps in.
What if it's a minor child?
Minor children, that doesn't work. So then the statute covers all that. So I mean, just do a will. Let's see. You can appoint a trustee or administrator for testamentary trusts. Testamentary trusts are, if you have a minor child, and you don't want them to get all your money before they're a certain age, you can put it in trust for that kid and name a trustee to manage the money until they hit that age. If you have an older child that will never be good with money, you can put it in trust for that child's lifetime, have a trustee, and then maybe upon that child's death, it passes down to your grandchildren. So trusts can do a lot of stuff like that. Well, then we always have successor trustees, and we always have provisions for appointing a successor if both are gone. Creation of trust for the benefit of the spouse, minor children. Second marriage situations, always tricky. And it's one of those things where, two people get together, one has 5 kids, one has 2 kids, and they don't want to really play that game as to whoever dies last gets to choose where all the money goes. So you can really protect your first family, so to speak, by using a trust. Leave everything in trust for your surviving spouse. Upon her death, it goes to your side of the family as opposed to her side of the family. But anyway, there's a lot of, so those are really control trusts. We do trusts for control, protection, and tax minimization.
When would you use a trust versus a will?
We'll get to that. Okay. Wills, how do they work? I think that was your question earlier. The document has to be in writing, signed by the testator and witnessed by 2 witnesses. We always do a witness affidavit because you have to prove that the witnesses actually witnessed the will. And in New York, we have what they call a self-proving affidavit. And when we do wills in our office, we have the witnesses sign the affidavit, so all you have to do is submit the will and the affidavit to the court, and it's self-proving. If you don't have a witness affidavit, you have to find the witnesses. And I've had to do that for people that come in and say, here's my father's will, I don't know who the witnesses are. Generally speaking, if you can find one of the witnesses, you're okay, but it just adds another whole layer of complication to the probate process. Probate, you all hear about that because, you don't want to go to probate. Probate actually in New York is pretty easy if you know who everyone is, that's your beneficiaries, and they all get along. So in order to probate a will, you have to submit the will to the court, the proof that it was witnessed correctly, and anyone that would have inherited had there been no will has to sign off on that, or they can object to the will. So that's another thing that people don't understand, is that, let's say you're a single person, all you have is nieces and nephews, half of them you don't know because you're not going to keep in touch with them. But in order to probate your will, everyone that would have inherited if there was no will has to be given a notice of the will, a copy of the will, and given a chance to object to the will. So, we're going to get to your trust question very quickly here. So, in the case where you have a situation like that, where you don't really know who or maybe your legal heirs, that you don't like them, you don't want to cause trouble. If you do a living trust, you avoid the probate process, okay? And so what a living trust does is it's a document that you set up now, you fund it now, and in it has all of your provisions, how you want your assets to go upon your death. And usually you name yourself as trustee initially, and then you name a successor trustee in case, obviously something's going to happen to you at some point that will carry on the terms of the trust after you're gone. As long as all your assets are in that trust during your lifetime, so bank accounts, house, everything, investment accounts, they have to either be in the trust, so, the James E. Prout Revocable Living Trust dated, whatever. Has to be titled that way on the account, has to be that way on my deed. As long as it's all in there and there's no assets in my name alone, I can avoid the probate process altogether. And if I were an individual that either had children that I knew that I wanted to cut out and I knew they were going to fight over it, or if I just had peripheral relatives that, I don't really know, I would go the trust route because then I could avoid that probate process altogether. Other will substitutes, beneficiary designations on life insurance or IRAs. Joint ownership, I talked about that before. Let's see, transfer on death accounts. This is the thing that bothers me most, is I'll do a whole estate plan for someone. I know where everything's going to go. They want everything to go 50% to this child, 25% to this child, and 25%. Okay. And then they go to the bank, and they open an account, and the bank officer at the desk goes, "Do you want to put a transfer on death on that?" And they go, "Yeah, sure, put it to my daughter." And so they come in with this will, and I go, "All right, so let's see. So we have this account. Oh, that's going to this daughter. We got this account. Oh, that's going to all your kids." And so it kind of blows the whole plan. So be kind of wary of when you go to the bank. Be a little wary about putting things either in joint name or transfer on death, because joint name is going to go to the surviving joint tenant, and if it's in joint name, it'll go to the surviving joint tenant. So let's say you have $100,000 in your checking account, and you go, "Well, I want my kids to have access to this, pay the funeral, do all this stuff. So I'm going to put my daughter's name on that as a joint account. So when I die, my one daughter gets that $100,000. It's hers, and my other daughter might not like that, So kind of be really careful about doing things like that. It can really throw the balance of your estate off. Now, I'm hoping that my one daughter that got the $100,000 would share it with her sister, but there's no guarantee of that. So rather than mess around with that, just stay away from those joint accounts. Unless it works. I mean, you only have one daughter, that'll work.
So in that case, can the daughter that's been shunned contest the will? Or
Well-
contest the living trust?
All right, so I guess it can always contest a will, but if it's a joint account, it's not a probate asset. So contest the will. The will might leave everything 50-50. So you can't contest a will if it's thrown out and you don't get any better off. So really, all you've done is you've made one of your assets a non-probate asset that's going to go somewhere over here, and then everything else will be divided 50-50. So contesting the will really does nothing in that case. In trust for accounts, these are all kind of the same thing, you set up an account in trust for your grandchild, whatever you do. It's okay if that's what you want, but don't get caught up in like this unexpected result. Like, oh, I didn't really want my one daughter to be favored over the other one, so just be careful of that. Revocable living trusts, they're also good if you have property in more than one state. A lot of people have property in Florida, property in New York, because we all know what New York is like in January. And so if you do have property in more than one state, if you have it all in a trust, then your trustee can manage all of the property and not have to probate the will. If you have New York property and you have Florida property and you die a resident of New York, you have to probate the will in New York, in the county where you died, and then you have to take that will and you have to probate it in Florida, where the property is that you own in Florida. And so it's just an added cost. It's called an ancillary probate. You have to hire a Florida attorney, go through the Florida probate process, and it's something that can be avoided by just using a trust up front.
All right, why don't they just have trust instead of wills then?
What's that?
Why don't you just have trust instead of wills?
A lot of people do prefer trust instead of wills. I have a will, I didn't go the trust route. I trust my family to do it the right thing,
That's good.
as all lawyers should not do. So anyway, a lot of people do the trust route. I guess the people are kind of leery of trust just because you don't really, you still own the property. They're revocable. So if you revoke it, it all comes back to you anyway. They're amendable. You can change it whenever you want. A lot of people just don't want to go through the whole process of getting their deed transferred over, going to the bank, getting all their accounts put in the name of the trust. So I just think that's really what it is. I think that. And it does cost a little more to do a trust than to do a will, because we're actually doing a lot more stuff up front. You're doing deeds, you're doing making sure that assets are funded into the trust. Because you can have the most beautiful trust in the world, but if you don't put all the assets in it when you leave the lawyer's office, you got nothing. You got a piece of paper that says something, but that's all you have.
I had a situation where my dad did have a will, and nothing went through probate, but I could not transfer his car because it was in his name.
Yeah, well, so you had to do a small estate proceeding probably. Yeah, so you can have up to $50,000 in your name alone, and they call it a small estate proceeding in New York. So it's a voluntary administration. It's really not a full probate, but you have to. It is a court proceeding, and you have to get these letters from the court that allow you to transfer that piece of property. So yeah, that's another thing with trusts. I mean, a lot of people don't put their cars in there. That's kind of a nuisance, But whenever.
New York won't let you register more than one name.
What's that?
New York doesn't let you register more than
Well, you'd have to transfer your car to the trust. So now the owner is the trust. Again, it's a hoop you have to jump through, but works.
So if you have a will, say we have a will, my husband's car is in his name. So in his will, and everything's left to me,
So then you're fine.
because all of his property is left to me.
Correct.
It's the advantage of the will over the trust.
Yeah, but when we do a trust, we always do what we call a pour over will. So that if you have any of those odd assets, like the shoebox full of savings bonds that you forgot about that's in the closet, then what happens is you probate the will. If it's more than $50,000 worth of stuff, you probate the will. The will says, I leave everything to my trustee under a trust deeded. And so then everything that you didn't get into the trust gets kind of swept up into the trust and administered that way. So
So really you should have both.
always when you have a trust, have a pour over will, yes. Just because you don't know. You might have won the lottery the day before and not got into the trust yet. So those are just different things. Also with cars and things like that, surviving spouses are allowed a car of up to, I think, $25,000 in value. I think every car in my driveway wouldn't add up to $10,000. So, but anyway, spouses are allowed one car. They're allowed like the personal property, $25,000 in cash. So I mean, there's some things that spouses are allowed anyway under the law. I'm going to move on now because we're moving right along here. Taxes and tax minimization. So this used to be a really important topic back when the federal estate tax exemption was $600,000. Now it's $13,610,000. So I don't have a whole lot of clients that have taxable estates at this point because between husband and wife, you can have $27,220,000 and not pay any federal estate taxes. But New York State is only $6,940,000. So we always take a look at when we're doing an estate plan, we always take a look at the whole thing, see what it adds up to, see if you're getting close to at least a New York State taxable estate, because there are ways that we can minimize estate taxes using trusts, using charitable gifts to your diocese or your church, things like that. Gifting during your lifetime. Everyone's allowed to give $18,000 a year to any individual. So if you have 4 kids, 4 times $18,000, boom, 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 boom. Get rid of all that without even filing a gift tax return. I don't know if you want to hear any more about estate taxes. It's kind of a topic that we don't dwell on too much anymore. Most of our trusts that we do now are controlled trusts as opposed to tax planning trusts.
Life insurance is like tax and
Life insurance is includable in your taxable estate. Yes, it is. One of the ways that you can remove, let's say you had a taxable estate. You had a $1 million life insurance policy. So you really didn't want to add another $1 million to your taxable estate. You can do what they call an irrevocable life insurance trust. And you can put that, transfer it during your lifetime. The the policy into the trust, and then it's not includable in your estate anymore. There's gift tax consequences if the cash value is more than $18,000. So if you're going to do a lot of our clients do irrevocable life insurance trusts when there's very little cash value in their life insurance policy, so that they don't get hung up on the gift tax issues. Let's talk a little bit about charitable gift planning. All right, so there's we all hear the word plan giving, right? And I think a lot of us think that that's only for really rich people. Oh, I don't need to do plan giving. That's for the super wealthy. But it really isn't. I do a lot of. A plan gift is anything other than just writing a check. So I call that a non-planned gift. Your annual pledge to your church, gone. You didn't plan that. You just wrote a check. But you could, and we'll get to your point. Well, you could do your annual pledge to your church like a planned gift, and maybe throw off a little bit of that IRA that's fully taxable to your beneficiaries, and use that to pay your annual pledge to your church. Talk to your IRA advisors about that, but that's a planned gift. Another planned gift. Let's say you have. I'm trying to think of what stock is really appreciated. Say you have Apple stock, okay? And you bought it a long time ago, so your tax basis is like zero. It was just a startup or whatever when you bought it. And now it's worth like $100,000. If you can give away shares of that stock to pay your annual pledges and not incur any capital gains. So you give away $5,000 of stock to the church. Church takes it into their stock account, sells it. Church has to pay the capital gains on it. Church's tax rate is 0. So you just gave your church the full value of that stock. You didn't incur any capital gains. You managed. You got your pledge paid. So that's a planned gift. Other planned gifts. I think that low basis stock is one of the IRA distributions, distributes directly from your IRA. If in your estate plan, let's say you decide to give 1/4 of your estate to your church and 3/4 to your kids, and you have an IRA that's worth about 1/4 of your net worth. But you go, oh, that's my IRA. I want to give that to the kids. All right? If you give that to the kids, when they pull it out in the 10-year period, they have to pull it out. They have to pay income tax on that whole thing. If you give that asset to your church, they pull it out, they got to pay on their tax rate, 0. So that's a good way to leverage your IRA. I have clients that have substantial IRAs, but not huge IRAs. But they leave that all to charity, and they obviously are taking the minimum distributions now while they're alive. But when they're gone, it goes to charity. They leave their other assets to their kids. Kids get a stepped up basis on death on stocks. So that Apple stock that was you bought for $1 and it's now worth $100, now gets date of death value for the tax basis. So now when your kids sell it, they only have to pay capital gains on what they make over $100 a share. So I guess that's one way of leveraging IRAs. Some organizations offer charitable gift annuities. I don't believe the Diocese does, because they're pretty heavily regulated by the New York State Insurance Department. Basically what it is like I could give $10,000. A lot of colleges have them. Give $10,000 to my college. They'll pay me back at a rate of 6% a year for my entire life. They have to have enough money in order to cover that. So might exceed the gift at some point. So that's why a lot of organizations don't have them, because they're so heavily regulated. But there's also charitable remainder trusts. So let's say that you really need your money now. You need it now because you're living on your assets. But you're not going to need it someday. And so let's say you take $100,000, put it in a charitable remainder trust, at a 5% payout. Let's say you had stock that was paying out 2%. I put it in a charitable remainder trust with a 5% payout. I just increased my payout. You do get it's a calculation. You do get a charitable contribution deduction of some sort. I get 5% for life. Upon my death, whatever's left goes to the charity. And so that's a way to kind of leverage your money to make sure you're provided for during your lifetime, but also take care of the church or whatever upon your death. I keep using the church. Could be anyone. Charitable lead trusts are the opposite. You put money. This is how the Kennedy Onassis leveraged her money. She put in a charitable lead trust for like 20 years. Charity's got all the income for 20 years on that. And then at the end of the 20 years, it went to her family. Unfortunately, I believe her son had already passed at that point, but her daughter was around. And so that's kind of, again, I don't do a lot of these anymore because a lot of people don't have like $13 million estates that they're trying to protect. But they don't have to be $13 million. I mean, it could be a moderate estate that you want to make sure the charity is taken care of, but you also need the income during your lifetime. So it's not just for taxes, it's to help reach your charitable intent as well. Any questions so far? Because kind of I have time. Yes.
So an example would be, you make a bequest or a trust to your church.
Okay.
And the church then closes or is merged. What happens?
Usually,
Every provision
yes. Usually, there's a provision that as long as it's another 501c3, you can change the ultimate beneficiary as long as it's a 501c3. So that happens a lot. That happens, put in a charitable remainder trust, and then all of a sudden you don't like that organization. They did something you don't like. Usually there's a provision in there where you can change that ultimate beneficiary as long as it's a 501c3.
But once you give it to the church, when you die,
Once it goes to the church, it's the church. It's like, yeah, whatever it says on your death is where it's going to go.
but if the church burns before you die, then you can say, well, that's no longer a viable entity. I'm going to change it to the SPCA.
Well, hopefully they had insurance, so it's still a viable entity. But yes, you can
But
do
I mean,
that.
they say, okay, we're just not going to have another church here.
Yeah,
Then we're dissolving our church.
yeah. Every once in a while we come across an old will that leaves. I just had one last year that left a bequest to an entity that doesn't exist anymore. And we just told the court, had proof that doesn't exist anymore. And so that particular bequest went proportionally to the other beneficiaries. Same with individuals. If you leave a bequest in a will to an individual that dies before you, and if your will provides that if they die before me, this gift lapses, then that gift just goes away and it's divided among whoever else is left. Anything else? I mean,
Just curious, two questions. One, once you have a will, can you add a trust to it, like for the house?
okay.
Does it have to be inclusive for it?
All right. So you're talking two different things. Yes, once you have a will, you can always do a trust. All right? And if you're going to go through the trouble and expense of doing a trust just to put your house in it, you might as well put all your assets in it and then do a new will that becomes a pour-over will into that trust. So, you might as well just kind of rethink your whole plan at that point.
So a trust is current, and the power of a will is anything you want.
Anything you forgot to put in the trust. Yes. Yeah. Also, we're on the topic of giving to the church and diocese. You can also do that in your will. That's an easy plan gift. If you have a will, I don't like to leave percentages too much with charities because then the Attorney General gets involved. But you leave a dollar amount. If you leave a dollar amount to your church or any charity, as long as your executor pays that dollar amount, then the Attorney General of the state of New York is involved. If you leave a percentage, then you have to do a full accounting and have the Attorney General sign off because they want to make sure that the charity got that percentage. So that's it just adds another layer of problem.
Legal fees for the
Probably more legal fees, yeah, because you have to prepare an accounting, you have to go to the Attorney General's office, they have to sign off on it. So yeah, it adds more hours.
What about in situations where you want to do a will or a trust and there's not an obvious executor, like a family executor?
Mm-hmm.
Some law firms will take on that role and some won't.
Yeah, it won't be law firms. Some lawyers will take on that role. Generally, I advise that you find someone other than me. And also a bank with a trust department will do it. Good friend, yeah. I mean, obviously, if there's no one, I've been executors a couple times, but it's really someone I've known really well, almost like a family member, and there really wasn't anyone else that would do it. But I generally don't like that liability part of it.
What if your executor, if I can follow up, if your executor, for whatever reason, feels he or she cannot take on this, then how does another executor be found?
Okay. I usually have at least 2 executors in my wills. A lot of times I have 3. So I have a primary, it's usually the spouse. I have a successor executor, usually one of the kids, and a second successor executor, who's usually another kid or a family or a friend or something. But if all of the executors are gone or can't do it, then the statute provides a whole array of, like a creditor can do it, the county administrator can do it. There's just a whole array of people that can do it. A beneficiary can do it. So yeah, I had an estate. It wasn't a very big estate a couple years ago, and no will. Okay, so single gentleman, no parents, no siblings, just a bunch of cousins. Hardly knew the guy. So we had to find all these cousins. I think there were 11 of them. And one of them, so in that case, the cousin or the individual that gets the most under the will, the most of the estate under the statute is the number 1 pick for the administrator. So the guy was 92, but he was okay. So we had him appointed. 6 months later, he died. So we started the whole process again. And again, this was the smallest. It wasn't big. I mean, it wasn't tiny, but it was less than 200,000. So we started again, and the next person that got the most, he was a young guy. He's in his 60s. Yay! 6 months later, he died. And we were just almost ready for final distribution. And so we had to go to the next one. And so I think it took over 2 years to close that estate, just because everyone kept dying, right? I get this phone call, bad news. I'm like, oh, you're kidding me. So anyway, so that, you do get problems. Probably more so if you don't have a will than if you do have a will, because, pick young people to be your executors, And I have that happen a lot. People come and go, well, I'd like my sister to be trustee for my kids. And my sister, the sister is older than the person, and the trust goes on for 20 years. And I'm like, your sister going to be here 20 years from now? I mean, is that really a good choice? Make sure you have some successors in there. So I always have people look at the ages of individuals and things like that. So to make it kind of practical. Any more trusts, wills, tax?
Yeah, how much cost you got a will? What's the other?
Well, that depends really where you go. I would say for a simple will for a couple with the healthcare proxy power of attorney living will, you're probably looking at $1,000 to $1,500 for the whole package. I might be low. I don't know. I might be high. I don't know. I don't really talk to other people. But anyway, that's kind of.
But don't do it yourself.
Don't do it yourself, because if you do it yourself and you mess up, there's no fixing it. You're gone. So yeah, it's the cost of a couch. Couch or will. I always look at it that way. And if you have young children, definitely do a will, just because. And if you have children with young children, encourage them to do a will, to at least appoint guardians and make trusts for their kids, because it's a disaster if you don't have a will and you have young children.
So if you're in your 20s, you can do a revocable trust
Oh yeah,
so that you're providing for your young
yeah.
child.
Or you can do a will with a trust under your will. So you leave everything to your spouse. If you're both gone, everything goes to my kids in trust until they're 25. That kind of thing. I have people come in, my kid's going to be 25 next year. Let's make it 35. Okay. My kid's 35 next year. Let's make it 80. Okay.
So I work with a lot of people who don't believe that trusts and wills are important.
Okay.
They're young, they think I need my cash now and my kids will be fine. But is something like trustandwill.com a better idea versus them not having anything at all?
I've never been to the site, so I don't know. There used to be, I don't even know if it's still around, a thing called LegalZoom or something like that. I've seen some of the wills that come out of that, and I actually had to probate one. It went through probate, but it left money to 17-year-olds. It just said, in trust. For what? Did the trustee have to hold it all until they were 21? Could the trustee use it for their benefit? It's all dead, And so my interpretation was, all right, hold it in trust till they're 21, but you can't touch it till they're 21. So if they have to go to school and they don't have enough money, sorry, you got to hold that till they're 21. So yeah, I just think that going to a professional and having a discussion.
It's so hard because I sit around and I talk to these kids and they don't think it's
Well,
important. Now, my neighbor died, she was younger than me, has a disabled son in the house, and no will.
Now that's a good thing too. All right, so if you have disabled children,
Right.
there's a what they call a supplemental needs trust, and so you don't want to leave. Well, maybe you do want to, but it's usually an advantage to leave money to a disabled child in a supplemental needs trust, because then they can still get all their government support, and the supplemental needs trust covers things that government support doesn't cover. So,
You're impoverishing them.
you're not impoverishing them because they didn't have to begin with. What you're not doing is you're not giving them so much money that they have to pay back everything that they've gotten over the last 20 years. And then whatever's left, they have to keep paying until it's down to nothing, right? So you leave, and the courts and the agencies that take care of these individuals, they love these things, because what it does, it provides, they want, let's take them on a vacation. Medicaid and social services aren't going to cover a vacation, but this trust fund can cover the expenses of a vacation and improve the quality of life for this individual, but not throw individual off the public assistance that they're getting. That's called a third-party supplemental needs trust. Now, if you left that money to the child or to the disabled individual, they could petition the court to put it in a supplemental needs trust. But that's called a first-party supplemental needs trust because it's their money. And so upon their death, it all goes to social services to pay back everything they've paid for. So third party, you don't have to pay back. First party, if it's their own money, they have to pay back everything that was paid on their
But
behalf.
that disabled person, if they're capable, should have a will because of that money.
No, because the supplemental needs trust says what happens to it after they're gone. So they don't need, they don't have any control. They have no
The
control.
disabled person has no control.
Correct.
So
You have to have a trustee that has the control.
you have a trustee, and let's just say the trust started out with $1 million.
Yep.
Right? And the disabled person lives for another 10 years, and there's $10,000 left in the trust.
Yep.
Where does that go?
Wherever the trust says it goes. So if
So
that,
it could go to, say, another cousin in.
yes, it can go to your other kids. It can go to that disabled person's children if they have children. But the trust document itself says where it goes.
Okay.
All right, let's go. Let's kind of move on to the next thing. And I didn't know how many people were going to come here today, so if this is going to work, you want to pass these out. I didn't want to give them to you before, because I don't want you distracted. But you can be distracted now. And then you want to pass. So what
Are
I,
these the same or two different documents?
they're two different documents. So first we're going to talk about the healthcare proxy document, which is what you're passing out. And this is a power of attorney, I believe. So these are just kind of sample documents I ran off my computer. So not only do we talk about what happens to our money when we do estate planning, we talk about what happens to ourselves as well. And so the first one that, well, whatever one you have, there's one that says healthcare proxy, living will, and one says healthcare proxy, the other one says power of attorney. Okay? We all on the same page? All right. Let's talk about the healthcare proxy first. You doing? Healthcare proxy first. In New York State, you can't use a power of attorney to designate someone to make healthcare decisions for you. You have to use a healthcare proxy, which is what this is. Basically, just your name. I appoint so and so to make healthcare decisions for me if I'm unable to. And then you'll see that there's an alternate there as well. You can put more than one alternate, but you can't have more than one person acting at one time. The reason being, you can't say both of my children are the healthcare agents because they could fight. We want to avoid the fight, all right? And so you name one person to be your healthcare agent so that the doctors only have to go to one person. And so the way we do our healthcare proxy is like this. We have a living will attached to it. And a living will is where you say, you're signing this, you say you don't want to be kept alive on life support if it's only prolonging the dying process. Of course, you say it in a lot more words than that, but that's basically what you're saying. You're saying that you don't want, if you're in an end-of-life situation and there's no hope for recovery, you don't want cardiac resuscitation. You don't want mechanical respiration. You don't want tube feeding or hydration. You don't want antibiotics. You don't want anything that's going to prolong your life. But you do want maximum pain relief. And this is what, we kind of all know this is the morphine drip. This is the end of life thing where they put you in, basically a drug-induced coma, and you kind of just drift off. So that's what the living will says. That's your decision, as opposed to your agent making the decision. So if you name your kid as agent using this form, Your kid doesn't have to feel guilty about pulling the plug because you said pull the plug. Go ahead.
Is a most form,
That's something that we don't do. That's a separate thing. Yeah.
that's a matter, but it basically covers the same thing.
Basically
right?
covers the same thing, but that's the doctor's office. Does it?
Right.
They do that and they do DNRs.
So if you don't have a most form, you can bring this to the hospital?
Yeah, they call these advanced directives.
Right.
And so, like, all the times I go to the hospital, which unfortunately are more than you would think, I bring a copy of this with me. Because, and then they go, all right, great, all right. So anyway, yeah, I think if a hospital receives any kind of federal funding, which they all do, they are required to ask if you have an advanced directive. Okay? That's what this is.
I'm so concerned about whether we should give it to the hospital. You know, when you go to the hospital, people get it for minor things. You say you have this on your file. And I've been told that don't leave it on file with them because there may be some situations where you could be resuscitated and be okay.
Okay, so the theory of this is that if there is a possibility that you could be resuscitated, this doesn't give them permission to pull the plug. This is only if you're in the end of life situation, and that's the physician's determination. So I have a lot of physician clients that sign these, so I mean I guess it's okay.
So do you have to actually present this to, because they ask, you know, they always ask you, do you have a healthcare?
Yeah, a lot of times they don't ask
We
for it.
say yes, but we don't even actually have a copy of it with us. So then-
Yeah. So generally, it doesn't matter. They have to ask. I would suggest if you have one of these, make sure that someone knows where it is. I know a lot of the facilities, you know, the assisted living or those kind of facilities, they have a little vial that's in the freezer, and so they don't have to, you know, they know if you go to the hospital, in the freezer, there it is. All your papers are right there. They don't have to look in your closet or, you know, under the bed or whatever. So make sure that whoever you appoint knows they have these duties and knows where it is. I'm sorry, I can't hear you. Yeah, especially with like the DNRs. If the EMTs come to your house and you can't present the DNR, they have to intervene.
In the meantime, you're dying.
Um,
So if you were in a situation where you wanted to donate your money, your body to Albany Medical so they can take it apart.
Yeah.
Study your cadaver, is that included with this?
So on option D,
Uh-huh,
there's a thing about organ donation.
right.
And if that's, you know, if you're an organ donor, you check that because then it sounds kind of morbid, but then they keep you alive, you know, in order to harvest the organs.
Right, good at work.
They want good ones. They don't want to pull the plug and then like an hour later see this. So that's why.
So under limitations, you could put donating my
Yeah,
entire corpse to.
So that's kind of a separate thing. Albany Med has a anatomical gift program, and you have to fill out their forms, and then oddly, I mean, it sounds gross, but they determine upon your death whether or not they want your, you know, you say I give it to you, but you know, if you don't have everything, it's not any good to med students.
Don't you think most people that pass away in their 90s or on, they're not going to...
Probably they've had enough going on that everything isn't intact that med students need to see. Yeah.
Well, my father-in-law did that.
Yeah.
I'm breaking the law. He scattered his ashes in the lake.
It's allowed, as long as they're cremated.
As long as it's during the summer.
No, as long as he was done properly.
Yes.
Yeah, no, but
Let's give an
they
example.
took his body and sent it back like 3 years later.
We have a question here.
3 years later.
The importance of letting family know. I happened to get a call from a hospital. I wasn't even the next of kin. They happened to call me. I knew that my 90-year-old friend had made paperwork to have her body donated, and it worked out. But if they had not called me that morning inadvertently, it would never have happened.
Yeah.
So it's just really important, if this is important to you, that you let
Yeah.
everybody know.
Yeah, you don't want to get buried first, then find the form.
Yeah.
Yeah. No, that's a very good point.
And
Power
the
of
thing about the 3 years is they have up to 3 years to get those cremains back. They cremate the body, the rest of
I
it,
see.
and then they have up to 3 years to get it back to you. So they're not holding your grandfather for 20 years.
So let's just wrap it up with the power of attorney. This is a relatively new form, which they keep tweaking, but this is the most recent one. This form allows another individual to make financial decisions on your behalf. So healthcare proxy is health decisions. The power of attorney is financial decisions and things like signing nursing home applications, things like, anything to do with finances. The power of attorney form, back in the day, it was a one front back, and now it's, as you can see, it's a nine-page document. Back in the day, you didn't have to have your agents sign the power of attorney, so I think there were a lot of surprised individuals that got phone calls said, "Oh, we found so and so's power of attorney. You're the agent." What? So now the agent has to sign it. So your agent knows that they're being appointed as power of attorney. Yes.
If I have one and it's 3 years old, is that too old? Should I?
As long as it was the legal form when signed, they're grandfathered.
Okay.
The only thing that's different is the newer forms allow for gifting. We usually request that people sign a power of attorney that does unlimited gifting, and that's so that when their children come in and say, "Mom's in a nursing home and has $1 million, what can we do?" Well, if she had a power of attorney with full gifting powers, we can probably have the power of attorney, the agent, give away a lot of that $1 million and just leave 5 years worth of nursing home costs. It's close to $1 million, but it's not quite $1 million. But we can preserve some money because there's a 5-year look-back period for Medicaid, and so as long as you retain enough money to get through that 5-year look-back period, then the kids can distribute money to themselves in advance, and then whatever's left used for their care, and when that's gone, they can go on Medicaid. People are living in nursing homes for a long time now. My wife's grandmother was 17 years in a nursing home. Needless to say, we didn't inherit a lot of money from that. Yeah. So anyway, power of attorney. My basic package, like for what I consider a complete estate plan, is a will, power of attorney, and healthcare proxy. You're covering managing money while you're alive and incapacitated, because the power of attorney does that. You're covering where it goes upon your death, and you're covering who can make decisions for you if you're unable to healthcare decisions. As long as you're able to make your healthcare decisions, they're not going to ask your agent to do it.
Things change all the time.
Oh yeah.
And just to update something, that's not expensive, is it?
Well, all right. So it depends. Because
Change
all right.
percent of-
So, for example, you come in and see me, and you want to tweak your will. You come in with a will, power of attorney, healthcare proxy that I didn't do. I have to start from scratch. So for me, it's like it's the whole deal. Now, if you came to me, and a year later you want to change your executor, that's a different story, because then I can just pull your will up, change the executor, print it out, have you come in, and it's probably going to cost 80%. Give you a big discount on that. No, it'll cost less. We bill hourly, so if it doesn't take me that long, it's not going to cost that much money. And we don't usually, you don't redo powers of attorney every time the form changes. You do it when circumstances change, unless it's a really old form and the banks go, "What is this?" People still have those front back ones, and Banks don't even know what they are anymore because all the people that work in banks are too young.
Do you have your contact information?
Do I have my contact information?
In case you want to give to the church, we need.
All right, so yeah, I have a limited number of my contact information. Do you want it? Okay. I mean, if you have pens, I can tell you my contact information, but.
She's ready.
You ready? All right. Again, it's James Prout, Prout. My email address is jprout, jprout, @hhk.com. And my phone number, 518, I have to look at it because I can't remember, 754-4688. I had the same phone number for 30 years, and I've had this for 2. I still don't know it. Any final? We're good? All right.